Hi. We've been talking about how administrative agencies are staffed and about the ability of other policymaking entities to control what they do, sometimes through personnel decisions and sometimes through direct action. Now we're going to talk about how those agencies actually go about their business. The administrative state grew in the New Deal by a lot. Dozens of different agencies were created. We're just showing a few here, as the federal government tried a host of new programs to combat the Great Depression and stabilize the economy. As the administrative state grew, the congressional acts establishing different agencies sometimes laid out procedures for the agencies to use in doing their work, and sometimes didn't. After all, for much of the 1930s, New Deal Democrats were in control of both Congress and the executive branch, and legislators were basically confident that executive programs would be implemented as they'd want. But as the 30s turned into the 40s and as the country entered World War II, administrative practice grew more varied still. The New Deal coalition in Congress began to shift, and various factions within the federal government began to look ahead to a future where everyone might not be on exactly the same page. Administrative agencies had more and more power with more and more impact on Americans' lives. And there was a vigorous debate over whether there should be a broader overarching structure regularizing the administrative process generally, and if so, what it should look like. What emerged was the Administrative Procedures Act of 1946. The APA isn't that long, and I've asked you to read it for Monday in its entirety. Section 1 of the Act is just the name. Section 2 is a definitions section. Section 3 is what became the Freedom of Information Act, making it possible for Americans to find out what their government agencies are doing. Sections 4 through 9 of the Act, now codified at 5 U.S. Code sections 553 through 559, describe how agencies have to do their work. That's the real meat of the substance of the Administrative Procedure Act. We're spending the rest of the month right here. Section 10 of the Act is now codified at 5 U.S.C. sections 701 through 706. It's about judicial review of agency action, how courts check up to make sure agencies are doing what they should be doing. That's where we're spending the first part of November. The APA basically splits agency actions into two main categories. There's rulemaking and there's adjudication. Unfortunately, those categories aren't crystal clear, and a fair number of court cases have tried to sort out the difference between them. We'll get into that a little bit in the sessions ahead. Take a look at the statute in your book. Actually, take a look at the text. Follow along. The definitions section, section 551, parts 4 and 5, say that rulemaking is the process for making a rule, which is a statement of future effect designed to implement or prescribe law or policy. We've seen a few agency rules already, like the EPA's rules on greenhouse gases and power plant energy generation, or like OSHA's rules on COVID vaccines. If an agency says, from now on, certain entities need to change the way they do business, and those changes are intended to be legally binding, chances are good that's a rule. Think about standards that move people or entities down one path and away from another. The definition section of the APA, section 551 again, but this time parts 6 and 7, says that adjudication is the process for formulating an order, which is defined as anything other than a rule. Well, that was simple. But more seriously, if rulemaking is forward-looking, it's at least a good start to say that adjudication, all the other stuff, is mostly looking backward. It mostly assesses whether what somebody has already done is within what the law requires. There's one exception to that right there in the statute, and that's that adjudication is defined by the statute to include licensing. Not only taking a license away, but granting a permit or a license in the first place. The APA's main rules for how each agency does rulemaking are set in Section 553 of the statute. And the main rules for how each agency does adjudication are set in 554. In each of those sections, there's specific language that sets some procedures apart from others. Both the rulemaking and the adjudication section, both section 553 and 554, specify certain procedures that follow when something is, quote, required by statute to be made or determined on the record after opportunity for an agency hearing. These sorts of hearings are governed by separate parts of the APA, sections 556 and 557. They can be held in an office rather than a court, but otherwise they've got some features you'll recognize. Witnesses are sworn in, evidence is introduced, there's a hearing officer in charge. And all of that means that there are two ways to think about rulemakings and adjudications. There are versions of each with these hearings and versions without. The ones with hearings we call formal proceedings, and the ones without are informal. And it turns out this is where the action is. Congress hasn't required formal rulemaking proceedings with witnesses and sworn testimony and the like in very many circumstances. Most rulemaking is informal. There are some informal adjudications too, like a lot of grant making or permit approval. But for adjudications designed to gauge existing legal compliance, particularly where there's a possibility of taking away benefits or imposing sanctions, most of these sorts of adjudications are required by statute to be formal, subject to hearings, with a formal record and a right to some impartiality from a judge. We'll discuss informal rulemaking and formal adjudication, where most of the action is, more this week and next week ahead. Formal adjudication is going to feel a little more familiar, more like a court trial. So let's spend just a moment on the informal rulemaking process, which you may not be as used to. Informal rulemaking is otherwise known as notice and comment rulemaking. Here's one view of the process. First, agencies have to figure out whether a rule is necessary at all. That may come from internal evaluations. Somebody at the agency may raise a flag. Or it may come from external pressure from other government entities like the president or Congress or the states, or from private lobbyists, including nonprofits, public interest organizations. Then agencies have to figure out what their proposed rule is going to say. That involves getting the substance right, but it also involves figuring out the right text with careful drafting to convey that substance. Once a draft proposed rule has been prepared, there's another stop for quote-unquote significant rules in agencies that aren't independent. Essentially, that's a stop for any rule that's a big deal, significant economic impact, or significant political consequence, issued by any of the big cabinet agencies. By executive order, those types of rules are all sent to OMB, the Office of Management and Budget, and specifically, the Office of Information and Regulatory Affairs, or OIRA. OIRA, which is part of the Executive Office of the President, reviews each of these significant rules, usually a few hundred per year, to make sure that each is in line with presidential priorities. OIRA also often asks other agencies with equities in the process, agencies that may tangentially be affected by the rule or have expertise to offer. OIRA asks them for input at this stage as well. OMB sign-off may mean a few trips back to the original agency, the agency that wants to promulgate the rule in the first place, until the proposed rule is ready for prime time. Then, the Administrative Procedure Act says that it's time for notice and comment. All potential rules, including rules that didn't have to go through OMB review, have to be published in order to give notice of the potential rule and solicit comments from the public. Notice and comment. These potential rules, along with a lot of other government activity that isn't rulemaking, are published in the Federal Register. The Federal Register is, as it says here, the daily journal of the United States government, a record for the executive branch, a little bit like the congressional record is the record for Congress. Every day, there's a new edition. But you can also search the Federal Register by date or citation or topic. In addition to looking in the Federal Register itself, which is organized chronologically, you can also find rulemaking activity on regulations.gov. Remember that EPA rule from our second class on making sure power plants used clean energy? This was, if you recall, the nice new shiny clean plant. Well, you can find the rulemaking docket for that rule, like any other regulation, on regulations.gov. And that docket will help you find, for example, on June 18th, 2014, the EPA's publication of the proposed rule in the Federal Register. After providing this notice, agencies making rules have to receive public comment. That's exactly what the proposed rule was for, to get people ready to submit feedback. And this rule got a lot of attention. There were over 4 million comments submitted to the agency. Once comments are in, the agency has to address them. Yep, all 4 million. Comments are grouped and categorized to make clear what their concerns are. And the agency can decide to make changes in line with the comments, to make totally different changes, or to decline to make changes in light of the comments. But in each case, even when rejecting the comments, the agency has to explain its rationale, why it chose to go that way or go a different way. At least it's got to explain a little bit. Then, once the agency's reacted to the feedback, we go through the process again. Careful drafting of a final rule, making sure everything reads as it should, including any substantive changes based on the comments. Another trip to OMB, and another opportunity for other executive officials to give feedback. And then, finally, another trip to the Federal Register to publish the final rule this time. And here's the EPA's final rule for clean power plants on October 23rd, 2015, more than a year after the proposed rule was issued. Especially for rules this meaningful and this complicated, the process can take a while. And that's a quick overview of the APA, the Administrative Procedures Act, with a little deeper dive into rulemaking. You'll get to know the APA a whole lot better over the next month. See you soon.